I've been asked today to take a few minutes to say something meaningful and personal about a mediation experience. After reflecting on this assignment and keeping in mind the need for brevity, I've decided to share with you a lesson I learned in 3 employment cases. It was a significant lesson, but one often overlooked, and that is the need to listen carefully to the disputants and not just to their attorneys. In mediation, I spend most of my time in caucuses with the parties, talking to them, conveying offers and counteroffers, transmitting information, packaging proposals in new ways, and frankly, pleading with everyone to be reasonable. Very frequently, the attorneys do most of the talking because that is their job. They have researched and prepped their cases, and they are there to represent their clients and make sure that demands are properly expressed and mistakes aren't made in the timing and presentation of offers and responses. But sometimes the attorneys can miss something in their zeal to achieve a favorable outcome. And the mediator can also miss the forest for the trees in her desire to get the parties to settlement. This oversight is usually not a problem if the mediation goes according to plan. No doubt it may take a long time to get the parties to agreement, particularly if there is a personality problem in the parties or if their goals are unrealistic. But in many cases, the goals, frankly, are focused on damages, money. And if the mediator and the parties hang in long enough and negotiate effectively, a settlement can be reached. But what happens if they have negotiated for many hours or days and have gotten to a point where it seems that they have drawn a line in the sand and no further movement is possible? I had this happen in 3 cases where I thought I had tried everything to break the impasse. But the parties got stuck. And interesting, the amount of money separating them was not that great relative to the overall amount in controversy. Each side just felt it had been pushed enough and it wasn't going to make any further concessions. I do not have time to go into the details of each of these cases. Suffice it to say that the first case involved an African-American male professor who had been denied tenure at a major university, and he filed suit alleging racial discrimination and procedural irregularities in the tenure process. In the second case, an African-American female middle manager in a telecommunications company felt compelled to resign because of alleged gender and racial discrimination. And in the third case, it involved a Caucasian man employed in the broadcasting industry. He had been dismissed for performance-related issues, and he filed an age discrimination suit. As to the professor, he ultimately realized that he wasn't going to get tenure at that university, and that a mediated result was in his best interests. But he sincerely believed that the university had not offered him a sufficiently large amount of money to settle the case. In listening to him, I realized that not only were his pride and dignity wounded by the denial of tenure, but he was fearful about whether he would find another job. He and I talked, and I shared with him my background as a professor at Rutgers University. He told me about his research, which honestly was a bit meager with respect to publications. And I suggested to him that while going through the job hunting process, and maybe even before it, he make a real effort to get some of his research published, even if it was in small articles. Ultimately, when negotiations broke down, I asked him about his home office and his computer equipment. I learned that his equipment was dated and that his office at home was a bit meager because he had spent most of his working hours at his university office. I asked how he would feel if I persuaded the university to give him a new computer, printer, scanner, and maybe even a new desk or bookshelves. He liked that idea, and in the 11th hour, the university did, in fact, give him a gift card with several $1,000s so that he could purchase what he needed for his home office. The amount of money was several $1,000s, which was not nearly the amount of money that he initially was demanding, but he felt that with that gift card, he could go forward and have discretion to buy what he needed as he began new endeavors in life. As to the manager who felt compelled to resign from the telecommunications company based upon her perception of gender and racial discrimination, I should tell you that she was represented by her daughter, an attorney who used to work for the EEOC, and her daughter wanted to vindicate her and get her a lot of money. I listened a lot to the daughter, and then I began to listen a lot to the mother, and I realized that the claimant had loved her job, but had not been made to feel sufficiently respected. She told me that she actually felt forced to quit, but wished she could have stayed. In speaking one-on-one with her, I asked what the complaints were, and she said she didn't like working in a tiny cubicle rather than in an office, and she didn't like the fact that she didn't have a personal phone extension, even though other people of her status who performed similar work did have a dedicated phone line. After talking with her, the claimant, I changed my focus. I worked on heightening the company's sensitivity to what the claimant had felt and letting its representatives know she had never wanted to leave the job, but she felt undervalued and pushed into pursuing legal action by her daughter. The company listened, and the case ultimately settled with the claimant's return to work. She got some new perks, including a dedicated phone extension, a small office, and most importantly, some new responsibilities which she was eager to assume. The third case involved a man who had trouble accepting the notion that his work had deteriorated, and he was convinced that he was terminated based upon age discrimination. There was nothing remarkable about the negotiations, except that the parties reached a stalemate and refused to budge. But as the talks wore on, I had some personal time with the claimant, and I began to talk with him about families, and he confided in me that he had recently lost a son and was in deep pain. I felt for him and started thinking outside the box. The employer had made what it called its last best offer, and candidly, the amount of money was not unreasonable, but the claimant would not take it. I asked him how he would feel if I asked the company to make a donation to a charity of his choice in his son's name. Honestly, he was shocked but touched. I then went into the company's caucus, and after reporting that its last best offer had been rejected, I presented my idea about making the donation in the son's name. After reflecting on this proposal, which the company thought was highly unusual, it actually came back and said, the key spokesman said, "We won't give him another dime, but we will make a $10,000 donation in his son's name, assuming we can agree on the charity." Well, they did agree on a charity that the claimant suggested, and the case was settled. The claimant not only withdrew his lawsuit, but he felt respected, and even more importantly, he felt his son had been honored. So what's the moral of this story? Disputants are people with feelings, and that means it is always important to remember that settlements are easier to reach if both sides can save face and walk away believing that the settlement was not just about making concessions and giving in. And for the mediator, the work is not just about understanding the parties' official positions and what their attorneys are saying. For the mediator, the task is always to listen carefully to the parties, to read between the lines, to confer with the disputants and develop credibility with them, and then to try to think imaginatively about what might settle the dispute. Thank you.